Hello, as you know, I am Ralph Crystal, and I am here today with Dr. Jackie Rogers, and we are pleased to be with you today. And we've been asked by the instructor of the class to talk with you about rehabilitation counselor roles outside of the public rehabilitation, the state rehabilitation agency. And I know that you've had a lot of this in other classes, so some of this will be a review, and some of this is going to be an expansion of some of the things that we've already talked about. We're going to be talking about some roles that you'll have in proprietary rehabilitation practice, and we're going to talk about how you can get training for this, and we're also going to talk with you about ethical issues that may arise. And as we go along, we'll probably have a few examples to talk with you about. So, first thing are some areas that rehabilitation professionals can practice in outside of public rehabilitation. And as you see on this list, we have worker compensation, disability case management, long-term disability, expert witness work, Social Security disability, ticket to work / employment network activities. So these are some areas that rehabilitation professionals who would like to work outside of the public rehabilitation sector, as well as facilities, rehabilitation facilities that support the public rehabilitation program, can work in. Now, on this list that I've given you, there are areas here that overlap, so it's not as if these are totally discrete areas. I would say that overall, the majority of people who work outside of the public rehabilitation program are going to be working in worker compensation. That's probably the major area. And disability management cuts across worker compensation, and it cuts across long-term disability. We could probably add in long-term disability, short-term disability as well, but I'd say long-term disability is probably more prevalent. What we do in worker compensation is to work with individuals who have had work-related injuries, similar to what we might do in terms of long-term disability. And I'm going to get into that in a few minutes. The next two areas, litigation support / expert witness and Social Security disability, really fall into the same area of forensic rehabilitation practice. And there are some occasions, not too many, but periodically, where you'll find somebody who is a practitioner in worker compensation doing case management and job placement, who will also be called upon to do some sort of expert testimony work. And then you might find some people who do worker compensation, case management, also will specialize in expert witness work. So you might have someone who does purely worker compensation, and then occasionally might be asked as a part of one of the cases to do some expert witness work for that case. And you might find some people who do litigation support and expert witness work who also do the worker compensation, long-term disability, case management work activities. Then you'll also find some people who make a career out of doing expert witness and Social Security work, and you'll find people who just put their eggs in that particular basket. That's, in my judgment, that's probably not the best basket to put your eggs in. If I were to make a recommendation, my recommendation would be to mix what you do some job placement and case management and worker compensation and long-term disability work, and also, if you have that interest in expert witness work, to be involved in those activities as well. The last area that I've got is ticket to work / employment networks. This is a program, the Ticket to Work program, as you know, is a federal program. It could kind of cuts across public and private sector practice. It's a program that attempts to return people who are receiving Social Security disability back into employment. And kind of my sense of this is that you can function in this area, but you can work in this area. I'm not quite certain how successful people are going to be, because the vast majority of people on Social Security disability have worked very hard to prove that they are disabled, and they're not going to turn around and say, well, I'm no longer disabled, I want to go back to work. I do believe you'll find a small percentage who will say, I'd like to go back to work. I think of that small percentage, you will find people who, when they got on disability, had that in mind, that they really would like to get back to work. You'll find probably a larger percentage of that small percentage who may have an interest or may not have an interest, but I would say a very small fraction of that percentage, and I've divided that percentage up quite small, even though it's less than 1% to begin with, I believe, who really have no interest and don't know and don't believe they can go back to work, even though they might express some degree of interest in looking into the Ticket to Work program. But that is an area that people can practice in as well. And basically, it's coordinating and providing services, or coordinating services, and the configuration varies depending upon the nature of the case involved. Dr. Rogers, any comments on any of the areas that I've just described that you'd like to add at this point?
Well, with respect to the workers' comp cases, of course, these are cases where someone has been injured on the job, and it has to be work-related in order for them to receive workers' compensation benefits. Most of the private sector work with workers' comp claimants, like you said. However,
Let's
there's
stop.
also the problem.
Tom, why don't you stop? What's wrong, Tom?
I wasn't prepared for that. The mics in the room are not on except at the podium.
Well, let's change that. When we back up, well, Tom will edit it.
Okay. There's not any mics in here.
So we had a good time crashing to an unfortunate vehicle.
I thought you were talking about the Mercedes, but you were talking about his new Jeep.
You got a Jeep. Okay, go ahead.
Are we ready?
Ready to go. Tom says we're ready.
With respect to the workers' comp cases, like you said, the majority of cases in private rehab tend to be workers' comp cases, but there is often a problem with motivation to return to work in those cases too, just like the Ticket to Work cases. Oftentimes you'll find attorneys involved in the cases, and it seems like the more a person is disabled from an occupational standpoint, the more money they can get from a workers' comp settlement in general, in most states, not in all states, but in most states. So sometimes that can affect their motivation to return to work, and that can be a problem when you're working with them from a rehabilitation standpoint. And with respect to the LTD cases, those cases are really pretty interesting to work with, and they're usually, when a person's on LTD, if they're disabled from their current job, regardless of what the job is, they can get long-term disability for about, usually it varies, but about 2 years, maybe a year to 2 years, and at the end of that time they have to be disabled from any and all jobs in order to continue to get benefits. So it's usually at that point in time, after they've been off work for a year to 2, that you tend to get the referrals for rehab for these individuals. Or that seems to be my experience anyway. That's all I had to offer.
All right, very good. We're going to come back to answer one of the questions that we were asked to address, and that is the expert witness work when dealing with worker compensation and dealing with the long-term disability, because those are two areas in which there is a lot of expert witness work that is done. There are some other areas, such as personal injury, which I'll also talk about, but that goes under the general category of litigation support. Now, just as a review, in terms of comparing and contrasting public and proprietary rehabilitation, we have, if you recall, in public rehabilitation, in public rehabilitation, we want to assist individuals achieve their potential. In proprietary rehabilitation, the philosophy is a little different, where we want to get people back to a prior level of functioning. And there is a potential for an ethical dilemma here, insofar as if we work in proprietary rehabilitation, we are obligated by the nature of how proprietary works to just get the person back to the level they were at, even though we might recognize that an individual has more potential to function at a higher level. And while I say there's the potential for an ethical dilemma there, it's something that I believe is not really a significant ethical problem, because of how the mandates are, and I'm going to get into that just in a few minutes regarding how public and private rehabilitation, particularly private rehabilitation, functions. Again, as a review, we recall that public rehabilitation is a state-federal partnership. Public rehabilitation is a national program. Public rehabilitation is based on eligibility. You have to be eligible for public rehabilitation, and the preference is to give services to people with the most severe disabilities. Public rehabilitation is funded with tax dollars. On the other hand, proprietary rehabilitation is typically administered by individual states, and each state sets the parameter for the program. And that particularly is the case in worker compensation. Worker compensation programs are run by individual states. It's not a national program. The one exception would be worker compensation for federal employees. Worker compensation for federal employees is a separate program, and we as professionals have the opportunity when they open up the roster to become professionals functioning in that arena and providing rehabilitation services to injured federal workers. My experience with that program is that it is somewhat broader and somewhat more liberal than most state worker compensation programs, insofar as its philosophy is somewhat closer to the public rehabilitation program, insofar as people can have the opportunity to go back to school, to learn new skills, not just to get back to a prior level of functioning. On the other hand, the individuals who get referred to us in the federal worker compensation system more closely mirror the types of individuals that we'll find in state worker compensation programs. As Dr. Rogers said, individuals who may not be all that motivated, who may be looking to claim a total disability, and when you work with those folks, they may appear closer in terms of temperament to worker compensation individuals, but the program itself, the federal program of worker compensation, is somewhat more generous, more liberal. Private rehabilitation is based on entitlement. In other words, a person is entitled to services if he or she meets the criteria for service. And in worker compensation, it's being injured on the job. And it's not funded by tax dollars. It's funded by insurance payments that people put in. And it's also important to recognize that proprietary rehabilitation is based on the notion of insurance. And this gets into that ethical issue I was mentioning before, because it's the way proprietary rehabilitation works for the most part is it's based on the notion of replacement for something that is lost. Insurance adjusters typically make referrals for services. And what that means is that, as an example, if you have an insurance claim for whatever, a car wreck or a robbery, a house burglary, that sort of thing, when you deal with the insurance company, at best, they're going to replace what was lost. Now, obviously, there are examples of things that can't be replaced. If somebody robs your house and steals you certain jewelry, you can't get back that particular piece of jewelry, so they'll give you money or they'll whatever to replace it. But they're not going to, but if you have a car wreck, for example, as a better example, I think, if you have a car wreck and you were driving a little Ford Escort or Cavalier, if they still make those cars, and you total it, they're not going to give you a Cadillac or a Lincoln, okay, just because you want one. They'll give you, you'll be lucky to get back the equivalent of what you had previously. And it's the same way in worker compensation dealing with injured workers, injured individuals. Now, I think Dr. Rogers wants to say some things here, so I'm going to let her jump in and add what she would like to say.
Okay, I wanted to say just a couple of things. In working with insurance companies, and in some states, well, like you said, the workers' comp laws vary from state to state. In some states, the workers' comp is covered by individual insurance companies. There may be 100 different insurance companies that write workers' comp insurance in that state. And just if you're an employer, just like you would go to an insurance company and get car insurance or something, you would go to an insurance company and get workers' comp insurance. In other states, there is an actual state agency that handles the workers' compensation coverage and handles all the claims with respect to it. Because in the states, in particularly the states that have the different insurance companies covering it, just like with any companies, you have some companies that are really good and really concerned about the person, and you have other companies that just want to save money, and that's about it. I have had experience with some cases anywhere from working with an individual that you can't even get the insurance company to pay for the person's doctor visits, having to fight to try to get them to pay for their doctor visits in relation to the workers' comp injury, to another situation that was an individual, this is another extreme, but an individual that became a paraplegic as a result of a coal mining rockfall, and the insurance company actually bought him a wheelchair accessible brick home and made all types of alterations and everything. So there's extremes, and I want people to understand that when you're dealing with these insurance companies, you may come into a situation, an ethical situation, where you have an insurance company that's made referrals to you that you don't really feel like, you don't feel comfortable with dealing with that particular insurance company. And you may want to discontinue your association with that particular insurance company. It's just a matter of considering what's best for the person.
Yeah, to kind of put that a little different way, is that when you think of working as a counselor in the public rehabilitation program, whereas while there are going to be differences in that public rehabilitation program, it's basically the same program wherever you are, whatever state you're in. Now, there'll be some slight interpretations, and every state has to submit a state plan, but the state plan is based upon the federal law in public rehabilitation. And there'll be some individual differences. There'll be some judgment issues that'll vary from manager to manager about what should be provided, what should not be provided, and so forth. But what you find, what Dr. Rogers is saying, I believe, is that in the private rehabilitation sector, you've got a myriad of insurance companies all interpreting the state worker compensation laws differently. Some will push things right to the edge. Some will go over the edge. whereas some, will be pretty good about providing services. You'll also have, in terms of who they, sometimes it's like an iceberg, because you might find that they're very generous with a certain claimant for some reason, some certain disabled individual, yet the next individual they might be very kind of restrictive on, and you don't always know why. I'm not going to tell you why, but there could be a lot of undercurrents that are going on as to why they give a lot of things to one person and give very little to another person. In part, I think it's a function of who the employer is where that person was injured. It's a function of who the attorneys are involved. It's a function of who the physicians are, because different physicians are going to have more credibility. So you might have the insurance company looking at a report from a certain physician and saying, well, if this physician says this, then it must be so. So we better help this case out. And a lot of it goes even to the attitude of the injured worker. Because if the injured worker was a valued employee and was cooperative, they may be very willing to provide a lot for that person. Whereas someone who was perceived by the employer to be kind of a troublemaker all the time and always looking for some way out, the employer, as reflected through the insurance company who you're working with, may take a very hard line. And a lot of these things you don't know about, and they're not going to tell you. Sometimes they'll tell you, but a lot of times they won't tell you. Another factor that causes this variability is just the tremendous turnover in insurance adjusters. And they're going to, you could be practicing in private rehabilitation and working with an insurance company and an insurance adjuster, and doing a wonderful job, and they're sending all sorts of referrals, and the next day there's a new insurance adjuster, and that person's got a whole different approach and a whole different attitude, and then you're kicked on the street. And
or that person
so Dr. Rogers is going to comment on what I've said, so go right ahead.
Or that person, sometimes you establish a relationship with an insurance company and an insurance adjuster, and like you said, you're receiving all these referrals and you're doing an excellent job, and they seem really pleased with your work and you're delivering a quality service. And then that person moves to another job, or that person leaves that company or whatever, and someone else comes in, and that person may already have a relationship with another rehabilitation company or another rehabilitation counselor. And so they may no longer refer cases to you because they like this other person. They may not know you at all, but they just like this other person. And so your referral base may just totally dry up very quickly. But again, whether or not services are provided is based not only on the insurance company and on the individual state laws, but it's also based upon individual adjusters. Some adjusters will take a very hard line approach to whether or not someone is entitled to benefits or not. It's more of a prove it, show me situation. And others will be more lenient and more forthcoming with their efforts. And I think it's a lot of their experience in the field, with their past experience with injured workers, like you said, with the particular employers, with respect to the employees, whether they're valued employees or someone who has been there for 2 weeks and all of a sudden has an injury and they've got a history of prior injuries or something like that. So it's really variable, and it's very, very different. You can't count on a particular insurance company or insurance agent for continued referrals within the private sector. And you have to learn each individual insurance company and what they're willing to provide, the services they're willing to provide, and be able to look outside of that insurance company for alternative sources of funding if necessary.
Very good, thank you. I'm going to come back to some of those issues. I'm going to move on quickly in our review. Again, in private rehabilitation, you're going to have some people say 4-step, some people say 6-step, others 8-step approach to getting people back to work. And again, this is following that insurance concept. You go back, hopefully you can get the person back, the same employer with the same job. If that doesn't work, the same employer, a new or modified job. If that doesn't work, a new employer in a same or similar job. or a new employer, a new job. And at the bottom of the list, we have training and self-employment. Now, usually in public rehabilitation, training is at the top. But here we see training close to the bottom. And again, it's what Dr. Rogers is saying. The experience of insurance adjusters is that training in private rehabilitation, I don't like to say this, but I will, is that it usually doesn't work. You know, my feeling is training is good for everybody. The more you know, the more flexible and the more you're going to be able to do a lot of different things. Unfortunately, when you're dealing with worker compensation or personal injury, training doesn't always work because for whatever reason, either people who are not used to being in school or because they don't want to go back to school. Where training does work, what I have found, is when you have a younger individual, you know, someone who is just out of school, on the job a year or 6 months, and they get injured and they can't do what they were doing before. In that case, training is going to be more potentially effective. Okay, and I'm going to skip a lot of this, go quickly. Public rehabilitation focuses on persons with developmental disabilities, looking at habilitation, people who have never worked, as well as rehabilitation, people who've had some work experience. We use similar benefits in public rehabilitation. On the other hand, private rehabilitation focuses on persons with injuries, either at work or personal injuries. And another factor that comes into play here when we work with people is the feelings, is the emotion that someone has about how the injury happened. Being angry at the employer for not addressing that safety violation. Being angry at the person who hit them in their car because they ran a red light. And so when you get that, you know, people are more focused on a redress for that injury or for that reason for the injury, getting back at someone. And when I say get back at them, it says how much money can I get, rather than can I go back to work. So you find a lot of that in terms of underlying attitudes. And I mentioned the word money. I think you'll find in private rehabilitation that money is everything here. Okay, money is everything. Money is how much money is going to go into the claimant's pocket, how much money is going to go into the doctor's pocket, how much money is going to go into the physician's pocket, the lawyer's pocket, and how much money is going to come out of the insurance company's pocket, because they don't get to keep the money, they have to pay it out. But money is important, and I think you'll find that, you know, that we also have to think of money. So it's money in our pocket as well. And I'm going to come into that a little bit, because once you start talking about money, well, you know, in public rehabilitation, you know, people are all on salaries for the most part. So our decisions and the things we do are not going to be driven by how much money we're going to make or how much money we're going to lose. But ethically, some sort of overriding ethical issue here is, when does money drive our decision? When does money drive our decision to say, well, let me work for another 3 weeks on getting this person a job, rather than knowing we ought to cut it off now because we can send more billings in, and billing and how we bill is a big issue in private rehabilitation, because to stay in business in private rehabilitation, you got to make money. If you don't make money, you go out of business. And so it's a very basic economic issue for everybody who works in private rehabilitation. Now it looks like Dr. Rogers would like to jump in again, so go right ahead.
I'm not real sure that I want to jump in. I think that is true. There's a lot of differences between the private and the public sector, and having worked in both, it is very true that with respect to the private sector, you don't have a salary usually. Well, I mean, if you're starting out on your own, you don't have a salary. If you work for a private agency that has, you know, gives you a full-time salary, that's fine. But you still have to account for all of your hours, the billable hours, which means the amount of time that you can bill to an insurance company for your services. I think probably the hardest thing that I had to get used to when going from the public sector to the private sector is learning how to account for all those hours. It's really kind of difficult. But one of the things that you need to consider also is that even though the private sector is very concerned with money, in the public sector we are concerned about money as well from a budgetary standpoint. As a counselor, you're usually given a certain budget and you have to spend that budget wisely. Now, obviously, we don't, in the public sector, want anyone to be without benefits, but you still have to look at, you have to be concerned with budgeting issues. It's a different type of money situation in the private sector in that you have to be concerned with accounting for your time as opposed to budgeting to pay for services. The only other issue I wanted to bring up with respect to, and this is kind of backtracking just a little bit, with respect to the training issue and the difference between private and public sectors. It is true that the hierarchy, the six-step process in the private sector is generally followed almost exclusively in workers' comp cases. But interestingly, I had a case recently that a student in one of my practicum classes presented a case study, and in the case study the individual is a public sector, she was doing her internship or practicum with a public rehab agency. And she had a consumer that was referred, and this was an individual who was a registered nurse. She had a high degree of training. And so they were looking at trying to use the skills she already had. Now, she wanted to go on into a different training, totally unrelated to nursing. I can't remember exactly what it was right now, but she wanted to go back to college in a totally different field. And the counselor had to consider what skills and training she already had and try and see about utilizing those skills in considering whether or not to pay for her to go on just because she needed or she wanted to go on to another area when she could still be employed in some areas related to nursing, even with the disability that she had. So we don't always, in the public sector, we don't always jump to that training level immediately either. We also look at what kind of skills the person has to start with and see about using those skills in securing employment or a vocational goal. But certainly in the public sector, we're allowed to do training a lot more frequently than we are in the private sector. So that's all I wanted to say.
Good. Moving on. Again, as part of a review, the goal of public and proprietary rehabilitation is to return a person with a disability back to work. However, in proprietary rehabilitation, as we were alluding to, it's often adversarial because you got people with different interests, different perspectives. You're going to have an attorney who represents the employer. You're going to have an attorney who represents the individual. You're going to have physicians that have treated the person. You're going to have physicians hired by the employer who evaluated the person. You're going to have people with different agendas and different perspectives and coming up with different conclusions. And that can be confusing at times because you don't always know where the truth is in the level of ability and the level of functioning of a particular individual. In public rehabilitation, as we all know, we can rely upon existing data, statements from clients, support systems to determine disability. Anecdotal information can be utilized in public rehab. In private rehab, on the other hand, we're much more precise. Disability is going to be based on objective medical information as opposed to just taking the word for what someone says. If we did that, for example, if all the people who said they want to go on Social Security disability, all the people who say they want worker compensation, they would all, the vast majority, I shouldn't say all, the vast majority would be totally disabled. But the reality, because of the severity of things such as pain and then mental problems, that if you just take the word of what the individual says and a significant other or others, you'd be paying everybody total disability, and no one would be working. So that's not the way it works, unfortunately, or maybe fortunately. The way it works is that it's based more on objective information. And when I believe that that someone who would decide how severe someone's disability is does, in sort of a general thought process, is to take, like a judge, for example, a judge would listen to what the person says about his or her disability, would review the objective evidence, may take information from us, and then put all that together. So a judge, for example, would look at the objective evidence and say, is what the person's saying matching what the evidence says? And then would say, okay, if we take what the evidence says and we ask a vocational expert to say if there are any jobs a person can do, are there jobs, are these jobs, do they exist in where the person lives, if it's worker compensation, or can the person be retrained, or can the person perform this work? I'm getting into a little bit of the role of a vocational expert more in worker compensation than in other areas, and would make a decision as to how severe someone's disability is and what it is they can and can't do. We'll get into that in just a few minutes. In proprietary rehabilitation, impairment is an exact and precise assessment of physical and or mental disability. Occupational disability, the notion of occupational disability in private rehabilitation considers how old someone is, the education someone has, the work they've done, any vocational skills, and where they live. Now, where they live isn't always an issue in certain areas of expert testimony. It is in other areas in general terms. And we'll get into that in just a few minutes. And what we can do as vocational experts is to address the impact of these areas. Each area that we might function in expert witness work would emphasize one more than another. For example, in worker compensation, age isn't given as much significance, on paper at least, as it is in Social Security disability, where age, as you get older, begins to have an impact on whether a person can work or not. We'll get into that in just a few minutes. Public rehabilitation is concerned with matching the person with the job with regard to compatibility. In other words, do you like doing this job? Do you want to do this job? Not just that you can do this job. Whereas in private rehabilitation, the focus is going to be, in terms of jobs, more on documentation of ability to perform work, the existence of jobs the person can perform, and does not include whether the person likes the job or what the salary is. It goes back to the insurance concept. Why should an insurance company say that, well, okay, your vocational interests say you don't want to be a fast food worker, so you don't have to do that, and we'll just pay you disability. They're going to say you can be a fast food worker because your doctor says you can, because those jobs exist in the community, and because the vocational witness says you can do that. So, if you're paying insurance to an insurance company, wouldn't you want them to say that also? I mean, put on the role of being does someone who has to buy insurance. Rather than say, okay, well, you don't want to do that job because you don't like it, therefore we're going to raise everybody's insurance rates to cover what it's going to cost us to pay you disability. So sometimes you get into broader philosophical areas. Now, Dr. Rogers, do you want to comment on this?
Well, taking that a little bit further, let's look at a fast food worker and looking at the differences between public and private rehab. If you have a fast food worker, let's say you have a college student who's working on their undergraduate degree in, I don't know, let's see, really something difficult here, engineering or something like that. And they're just doing this fast food work for part-time money while they're going through college. Now, if they get hurt on the job and are referred to a private rehabilitation agency to get that person back to work, they're going to try to place that person back to work as a fast food worker or within that employer's agency. they are not going to look at the fact that he's got 3 years of college under his belt and he's going to be an engineer in a year. That's not even considered. Whereas in the public sector, if that individual came into you after having been injured at the fast food worker job and then having lost his job because he couldn't go back to that particular job with that particular employer or something, you would maybe help him, depending upon the disability and everything, continue his college education. So there is a big difference there. It's, like you said, with insurance, it's basically to supplement the loss at the time of the injury. It's not to enhance the person's abilities or expand on the person's abilities.
Okay, very good. Let's skip to roles and functions, and we're going to talk about expert witness work now, and then I'm going to finally talk about training to get into proprietary rehab. In terms of roles and functions, I've listed some primary areas. A lot of these are similar to what you might do in public rehabilitation: assessment of disability, case management, and coordination, which is part of that, vocational counseling, labor market surveys, vocational evaluation, employer consultation, employability skill development, job development and placement, expert testimony, and then marketing of services. I suppose the only area that we really don't get into in public rehabilitation from this list would be expert testimony, which you can do in private rehab. The other areas you do, but you do them in a little different way. The emphasis is a little different in terms of the questions that are being asked. But a lot of the roles and functions of what you do in a private rehab are very similar to what you do in public rehab, except where you do it's a little different, and how you do it's a little different, and the outcomes are a little different. But it's basically the same skill foundation that you would have from working in public rehabilitation. I would also say that leading up to a discussion very briefly of training to be in private rehabilitation, that whether you want to enter private rehabilitation or not, I think depends in part on your temperament, and because it takes a different temperament to function in private rehab than public rehab. I think we have the basic skills of being able to work in either public or private. It's just, is this an area that you want to work in? And it's a little different temperament. I think you have to be, as Dr. Rogers said earlier, you have to be more cognizant of time and money, be more involved in billing. If you have your own office, you got to make sure you can meet the payroll and pay your rent and telephone. Things you don't have to worry about when you are working in public rehab. So there are things like that are some differences. Marketing of services, for example, in public rehab, to a great extent, when we market services in public, we're kind of informing people of what we do and how we do it. In private rehab, you do the same thing, but you also add a bit about why you're good at doing this. You have to promote yourself a little bit more, because there are others out there also doing this sort of thing. Now, what I'd like to move into, unless Dr. Rogers has got some comments, is talk a little bit about expert witness work, because that was on our list of things to talk about. Before I do that, do you want to add anything? And as I said, I found that the majority of people who end up in private rehab who have a rehab counseling background. Now, you'll find others in private rehab, such as nurses or physicians and therapists, physical therapists. I'm not concerned about how they got there. But what I've seen of rehabilitation counselors, for the most part, there are always exceptions, but for the most part, most individuals who work in private rehab started in public rehab. There are some exceptions, but for the most part, they start in public rehab and say, gee, I like to go into private rehab. So the training, the experience, you kind of get by seeing things and by talking with people. But the basic skill foundation you get coming out of a master's program such as this one. Any comments, Dr. Rogers?
No, I agree completely with that. I think that I've started in the public sector and went to the private sector, and actually, even though I had my own business, eventually I actually worked for another agency, a private rehabilitation agency, for about a year or so. And I certainly wouldn't recommend that anyone try to just go into private rehab fresh out of college without any experience in the private sector, having worked for someone else. And I would recommend that they work in the public sector as well.
Let's talk a little bit about expert witness work. We are called upon frequently as expert witnesses, and we're called upon more frequently if we kind of get known that we do this, because not everybody can do this. Just as I said, not everybody in private rehab not everybody in public rehab can do private rehab. Not everybody in private rehab can also do expert witness work, because depending upon the venue, it can be quite stressful, and your reputation is very critical in that domain. Expert witness work basically entails things such as testifying about the nature of a person's ability to do work activities, to hold jobs. Each venue that we would work in, potentially in expert witness work, has different questions to ask. And those questions would vary. For example, if you are in worker compensation, those expert witness in that area typically is going to be in an administrative type of hearing venue. Administrative means it's not in open courtrooms. It's not in circuit court. If you testify in personal injury cases and long-term disability cases and employment law cases, you're going to be testifying more in open court, either through video depositions or asked to go down to the courthouse and testify in public. If you testify in Social Security disability, which is its own area, then you're going to be also in administrative hearings. Usually in worker compensation, either the plaintiff's attorney or the insurance company or the employer's attorney is going to call you, ask you to make an assessment of an individual, and then to testify. The same as in personal injury. Either one side or the other is going to ask you to testify. In Social Security disability, you have to get on a roster of vocational witnesses with the Federal Office of Hearings and Appeals, and then those witnesses are called by the judge on a rotating basis. In worker compensation, and I think I really narrowed it down to 3 basic areas where you might testify. One would be a circuit court area where you open courtroom. The second would be worker compensation and related administrative hearings where you would testify either by submitting a report or by a deposition or sometimes appearing at a hearing. And then Social Security disability. Those are 3 distinct areas. And again, it's all about money. And I would say that the most adversarial, the most complex and litigious is going to be testifying in open court, because then you're talking about big money. Then you're talking about $1 million settlements. So if you go in, and if you're asked to testify for the employer or in circuit court, or for someone who is being sued because they ran a red light, if you're testifying for that side, you know, people don't want to just hear your opinion and say, well, gee, thanks for your opinion. I didn't know that. We're not going to give that person any money. Well, we're going to give that person a lot of money. Whatever side you're on, the other side, which stands to make or lose a lot of money, in the millions of dollars sometimes, is going to want to try to knock your credibility or to discredit you as a witness. So in that sense, it can get very adversarial. And if you're going to testify in personal injury cases, employment law cases, you have to be prepared for that sort of rigorous examination and cross-examination, and be able to answer sometimes very detailed questions about jobs and how jobs are performed, about your knowledge of the local labor market. And it can't just be because I think so, or because, well, you know, I had some experience years ago in that. The standard is it has to be based, your opinions have to be based upon a scientific knowledge basis for why you feel someone can work or not work, or why they can do certain jobs and how much money they can earn. In worker compensation, it's a little less adversarial, it's a little less litigious, but again, it can still be the same issues of if you're hired by the employer or by the injured individual. It can also get at times very litigious because, again, it's money's involved, and you are expressing opinions, and you have to be very careful that when you express opinions, whether it's in any arena, that your opinions are based upon the information that's presented to you, and that it's the information that you're expressing opinions on is that you can give things like DOT codes if you're asked, or you can be able to identify potential employers where someone could be hired potentially. In Social Security Disability, on the other hand, it's a little different. You're called by the judge, not by one side or another, and you're asked questions of a hypothetical nature, but the hypothetical question reflects the situation of the individual applying for disability. And you ought to answer questions such as, are there jobs, and if there are jobs in the national economy, how many exist? That's the Social Security concept. How many jobs exist? And it's a national program, so you don't have to be familiar specifically with a local job market, although that's always very helpful. And also in the Social Security disability program, getting a job is not an issue. So just because the job exists, you don't have to say whether the person is going to be hired or not. And you'll find that pretty much in the other arenas as well, but much more so in Social Security disability. Now, I've said a lot, and a lot of it's probably not very coherent, so I'm going to turn it over to Dr. Rogers to let her explain what I've just said and to add some things that she wants to say.
Well, I'm not going to explain what you just said, but basically I wanted to comment on a few things. With respect to the three different types, you have the Social Security, and you have the administrative hearings, or the hearings that are more like depositions for workers' comp cases and such, and then you have the more money-conscious hearing or cases that actually go in front of a court, where you're actually testifying, usually in front of a jury on stand, etc. In the cases where you're actually testifying in court, you can expect a serious challenge to your credentials in most cases, and your report. In most of those situations, workers' comp cases as well as the court cases, you will have seen the individual most of the time. You will have seen the individual, you would have evaluated them, and you would have completed a comprehensive report. Now, you may think that that report is very good, very comprehensive, but you can be assured that the other side, whoever is on the other side from the way that you have testified, that attorney will have sent that report. They will have received a copy of that report as well prior to you testifying. They will have sent that report to probably an expert, a vocational expert that they know, to pick apart, to try to find things that you are wrong about or that you can be questioned about. So when you go in front of the hearing or the court, you need to be prepared to answer and justify everything that's in your report. And if you can't do that, you're not going to come off looking very well. And in most cases, in the workers' comp cases, they don't spend a lot of time. You're doing a deposition, and most of the time you don't spend a great deal amount of time going over your credentials. Usually you will have your resume, your CV there for them to review. But there has been instances. Most of the time a deposition in workers' comp, in my experience, can last anywhere from about 15 minutes up to maybe an hour, maybe slightly longer than that. But I had a case one time that the attorney actually spent an entire hour, 1 hour of the 2.5-hour deposition, was spent on my credentials, going over every single job I had held, every single duty I had at every single job, the types of cases I had covered, the type of training I had had, et cetera, et cetera, et cetera. So it does take a person that's really confident in their own abilities and in their work to be able to testify in these types of cases. And that's one of the things I wanted to stress, was the importance of report writing. It is a legal document, and it represents you, it represents your agency, if you work for an agency. So you need to be very cautious about your report writing. And even in the public sector, if you write a report, you need to be very conscious about what you write, because it can be taken out and used in a court case at some time or another.
Well, you made some excellent points. Let me just add a few things. We've got about 2 or 3 minutes left. Just some other points along those same lines. In cases of personal injury or employment law, where you're in open court, in civil courtrooms, to a lesser extent in work compensation, the other side may have all the cases you've ever testified in front of them. You know, and so
in every article you've ever written.
In every article, but it's more I'm thinking more the cases that you've testified in, and they might pull up one and say, do you remember testifying in such and such a case where you said such and such? Now today you're telling us this other thing. You know, in other words, trying to make it look like your opinion's up for sale. And under the federal rules and state rules of testifying, the other side is entitled to see what it is you've said in other cases and when you've said it. And they're entitled, if they want, to all that information. So that's another reason to be very careful, as Dr. Rogers is saying, about what you say and how you say it, because things can come back to haunt you. And I've seen a lot of experts just kind of fizzle out over the years because they get caught up in too many webs that they've made, saying one thing one time, another thing another time, and their credibility, which is really your most important asset, is gone. They have no credibility. So you have to be consistent. And you'll also find, you know, when you get sworn in, you may be sworn in to tell the truth, the whole truth, and nothing but the truth. What you'll find the lawyers want you to do is they want you to stop when it comes to telling the truth. They want to stop at the truth. They don't want the whole truth.
Nothing but the
Okay, they don't want the whole truth, because what they'll do is they'll frame questions to give you the answer they want, which is the truth, but it's not the whole truth. For example, they may say, how much did you charge for this deposition today? Oh, and how much did you charge for your evaluation? So you say $1,000, and that sounds like a whole lot, and it is, and you'll say, but let me explain. And they'll say, thank you, you've answered my question. What the whole truth is, but I don't get that $1,000. You know, part of it goes for my rent and my secretary and other things. So that's what I mean, and yet be careful along those lines. Now, we're about done, and I appreciate your time today, and I hope this video has been informative. I know Dr. Rogers has had a lot of fun doing it, and I know you'll see Dr. Rogers on other occasions. So thank you.